Yes, this amendment concerns the approximately €80 million in tax relief that is given to film producers every year under the Section 481 relief. A very considerable relief to support the development of the film industry. But as the Minister knows, the specific condition attaching to this relief is that the relief, in order to access the relief, the film producers must provide quality employment and training, and they must comply with all relevant legislation in terms of workers' rights. And they must take responsibility for their employees and trainees. And this is what my amendment is asking for the government to investigate with a review in very short time as to whether that is actually happening. And I also add in, particularly in relation to the question of the acknowledgement of service of employees who have worked for those same film producers over many years, which, by the way, that acknowledgement of service, again, is required under law, under the fixed-term workers' contract law. Because despite your efforts, Minister, despite my efforts, despite the declaration form that the film production companies are supposed to fill in, where they solemnly have to commit to give quality employment, to take responsibility for employees, to comply with all employment law, they are flouting it, and they are flouting it brazenly and refusing to acknowledge the legal rights of their employees, blacklisting employees who actually attempt to assert their rights, blacklist them altogether out of the industry, as they have done to a significant cohort. And they are doing this in the most brazen fashion, Minister, and this is what I really want to get across to you. Because they are signing your declaration, which is the condition of getting this relief, committing to all of these requirements, and then they are walking into the Labour Court and the WRC and they are stating publicly that they are doing none of those things. Okay? So all you have to do in order to establish that the relief is being abused, that the law is being broken, that rights are being denied, is simply cross-check the declarations that are being given by these producer companies with the statements that they are making in the Labour Court and in the WRC when the workers who are engaged on these film productions, supported with public money, actually attempt to assert their rights, as they have done recently around the issue of collective agreements made with these film producer companies. And I just give you some evidence to back this up. A letter has gone to you this morning from representatives of the workers, just very briefly in 2 pages summarising the situation. I'd really ask you to appeal to read it carefully. But just to read you one of the submissions from one of the film producer companies that is, as we speak, getting money and has got a lot of money for many years, from the 19th of September in the Labour Court, where workers engaged on their productions took a case over breach of collective agreement. And this is what the producer said. These claims, this is the producer who signs your declaration, these claims were raised on behalf of a number of individuals who were previously engaged on productions associated with the respondent, i.e. the producer. Neither this complainant nor any of the complainants are employees of the respondent. Right? So they accept that they were associated with productions and employed on them, funded by 481, but then in an Orwellian twist say they're not our employees. They go on to say workers such as the complainant are engaged with designated activity companies, DACs, who are set up specifically for each production if and when commissioned. There are no employment contracts with the respondent. Any employment relationship exists between the employee and the specific DAC. As such, each DAC is the employer and there is no continuity of service where an individual is employed by different DACs. Yet this worker has worked for that film producer who gets the money from the state on the basis of complying with the Fixed Term Workers Act for 10 years. Okay, this is flagrant breach of the declaration. Similarly, the CEO of Screen Producers Ireland, on October the 6th, giving evidence in the Labour Court in another case between another producer, says in her evidence, "I will further give evidence before the court that there is no possible basis having regard to the realities of the sector on which a relationship of employment can be said to have existed between the parties." The parties being the employees who work on the film production and the film producer who gets the Section 481 relief on the specific requirement that they are the employer and that they provide the employment and that they acknowledge all the rights of the employees. Now, it couldn't be more blatant, Minister. So you have put out a declaration, very commendably, requiring them to give these commitments. They sign that declaration, take the money off you, and then go publicly into another state body and say, none of this applies to us. None of it. We don't provide employment to anybody. We don't have employees at all. And then they go the next day into you and say, give us some money because we'll provide some employment.
Thank you, Deputy.
You can't let this stand, and I'm asking you to seriously investigate these cases and withdraw 481 from companies that are abusing you, abusing the taxpayer.
Thank you, Deputy. No other Deputy indicating? No. So I go back to the Minister.
And I want to acknowledge the work that Deputy Boyd Barrett has done on this. Because he has been raising this matter now in many finance bills, and as he has acknowledged, it is something that I made a change to on foot of the matters that were being raised by Deputy Boyd Barrett. We did debate this at committee stage, and I'm not going to repeat the arguments again for Deputy Boyd Barrett because he knows what they are. He knows I take this matter seriously. As I indicated to him in the earlier debate, it is my view that the conditions must be met not just by a producer company, but also by the designated activity company, or the DACs, that were referred to by Deputy Boyd Barrett that are formed for the production of the film. If a producer does not comply with the employment and skills development requirements that are set out by the Minister for Tourism, Culture, Arts, Gaeltacht, Sport and Media, they may not be eligible for the corporate tax credit, and any amount already claimed may be recoverable with interest. The auditing of many of these matters in relation to employment rights legislation is a matter for the Department of Enterprise, Trade and Innovation. I am awaiting, as I said in the previous debate, the outcome of a process that is currently underway in the Workplace Relations Commission. And I hope later on this year there will be agreement on a framework approach to these matters in this sector. And that, I think, will be a really important step forward in how we can deal with the issue that Deputy Boyd Barrett and I have now debated over the last number of finance bills. My officials in the Department of Finance are following the process that is underway in the WRC. We hope that it can yield a successful conclusion, and we will then use a framework that may emerge from that as another way in which the different issues that we are debating here can be monitored. And I'll emphasise again on this matter that if further action is needed in this area, I will take it, because I do take this matter seriously. I will look at the letter that Deputy Boyd Barrett has referred to. I haven't seen it yet. It only appears to have been issued today to me. But I will look at that letter. But the next step for me is what happens in the WRC in trying to reach an overall agreement for issues within this sector. If that process yields an agreement, I hope it does. As I said, I think this will be then a further way in which the issues that we are debating here can be addressed.
Deputy Boyd Barrett.
Genuinely welcome your engagement and the commitments that you've made there. But I do think I've given you some new information, and I really hope you will sort of follow it up. And the letter that you would have got today elaborates that. Because there is an Orwellian, Janus-faced doublespeak coming from the producers who are getting the relief. Okay? They're telling you, in order to get the money, that they're going to do certain things, and then they're not just quietly not doing them and breaking those commitments, they're publicly breaking those commitments. And their representative from the Screen Producers Ireland is actually giving witness evidence in court against workers to the effect that the recipients of 481 could never be employers. Not just that they're not this person's employer, that they couldn't be anybody's employer. Now, this is a serious abuse. And these same producer companies are getting the relief year after year after year. And the consequences for the workers are very serious, because if the continuity of service, who somebody the respondent even agrees has been working on productions associated with them for 10 years, but that they are not the employer, it means their pension rights are messed up. The unfair dismissals doesn't apply to them. Rights that they have by law simply disappear because a producer who gets the relief sets up a DAC and says, oh, I set up that DAC, and I set up that DAC, and I set up that DAC, but actually I've nothing to do really with any of these things or the employees in those DACs. It's shocking. And the consequence is not just for those workers, but actually is for delivering on creating an industry where we have a permanent, developing, trained pool of workers who can deliver deliver the crew that you need to make films and indeed attract investment to film.
The Deputy has shared new information with me. I will look at that. I can remember the exact debate you and I had on this a couple of years ago, when I said to you that this tax credit is predicated on quality employment being made available. And you asked me the question in the Dáil chamber, if that quality employment is not available, what should happen with the tax credit? And I said to you at that point, we would then have to review how the tax credit has been made available and what the consequences would be for the company who's in receipt of it. And that is what we have done with the process that is in place. And I will look at the information that Deputy Boyd Barrett has shared with me, and I can just assure him of my continued interest in this matter and my hope that the process that is underway in the WRC, which I believe our debates and the action that I have taken in previous finance bills have been a catalyst for, can lead to changes that get the balance right between creativity in the sector, the fact that I know employment can change project to project, film to film, and also at the same time make progress on issues that do appear to me to be there from an industrial relations point of view and an employment rights perspective. We will continue to debate this matter last Council, and I will continue to be interested in it. And I hope later on in the year or early next year we can see a step forward in the WRC on this matter. Thank you.
We need to conclude. 2 minutes.
Well, again, I want to genuinely thank the Minister for those commitments and his engagement and interest on the issue. Just one or two other brief supplementary points for your consideration. There has been much talk about the possibility of an agreement, a collective agreement, as a way of resolving this. Now, I want to point out that the forum that was agreed by the Joint Oireachtas Committee for stakeholders, that the producers who I'm referring to essentially refused to go to that, and the people who are supporting no change in the situation and who are defending the status quo in terms of denying responsibility for employment. They refused and effectively vetoed that forum. One way to resolve that is for the Minister to say, just have the forum, have everybody in and hear the case in front of independent people like yourself who can look honestly and say, I hear your point, I hear your point, and who can adjudicate independently over it. Because there is intense lobbying coming from a certain sector who do not want the change. Okay? Now, if they've nothing to hide, or if anybody has nothing to hide, bring them all in. Let's hear from them, the different cases, and make a fair and independent adjudication. But in terms of a collective agreement, I just want to point this out to you. No collective agreement is legally possible if we're not talking about the employer and employee. So when there's reference to the SPI employment agreement, or a collective agreement, SPI are a representative body, they're not employers. And in fact, they are saying publicly, our members are not employers. So their members cannot, therefore, or they as a body cannot legally establish a collective agreement, because they're saying they're not the employers. Only employers and employees can have a collective agreement. And by the way, the Labour Court found that these same producers were in breach in the recent Labour Court hearing, in breach of a collective agreement that they had previously undertaken.
Thank you.